Hello, everyone, and good afternoon. Thank you for joining our Managing the Commercial Impact of the Coronavirus webinar and live Q&A. Before we get started on today's presentation, I'd like to go over a few housekeeping items. For those of you that may have questions about any of today's topics, we invite you to type them into the Q&A widget on your screen. We will try our best to answer all questions at the end, time permitting. However, if we do not get to all of your questions today, we will follow up with you via email. Please note the presentation portion of this webinar was pre-recorded late yesterday, Monday afternoon. We will go live near the top of the hour for the Q&A segment, which will last approximately 30 minutes. As an added reference, we encourage you to visit our Coronavirus Resource Center page on Foley.com, where we offer insights from across Foley's many practice disciplines on what companies can do now in response to the legal and business impact of the coronavirus, and how they can prepare for the future. An index of articles can be found in the resource widget located on the bottom left side of your screen. To receive coronavirus-related alerts in real time, please visit the Resource Center page to subscribe to our mailing list. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on your screen. I will now turn over to Vanessa Miller, who will introduce our speakers.
Hello, everyone, and welcome. My name is Vanessa Miller. I am a partner and head of litigation for the Foley Detroit office. I'm also co-chair of our firm's Supply Chain Solutions Group and one of the leads of the COVID-19 task force. By virtue of being in Detroit, I have a number of automotive and manufacturing clients with global supply chains. I specialize in supply chain and litigation and international arbitration. In addition to my litigation practice, I counsel clients on commercial transactional issues impacting their global supply chain. Joining me today as co-presenters are Kate Wagren, partner in Foley's Milwaukee office, co-chair of our firm's Supply Chain Solutions Group and one of the leads of the COVID-19 task force. Kate regularly counsels clients on commercial contracts. She is going to be speaking today about contract defenses to performance, including force majeure, commercial impracticability, and the defense of impossibility. We also have Carrie Hoffman, partner in Foley's Dallas office. Carrie is a Texas Board Certified Labor and Employment Attorney. She represents employers in all aspects of L&E law. She is a valued partner to her clients, providing advice and counsel on a variety of litigation matters and administrative issues ranging from OSHA, the NLRB, EEO, and wage and hour matters. She is going to be speaking today regarding the wide array of labor and employment considerations that companies are facing as a result of the evolving regulations related to COVID-19. Speaking today with us will be LG Sims, of counsel in the firm's Government Solutions, Attorneys, General, and Finance practices. He's based out of the Chicago office. LG has an extensive background helping clients solve complex legislative problems and advancing initiatives before various federal, state, and local government entities. In addition to his service with the firm, LG is serving his second term as the state senator for Illinois' 17th Senate District. He will be presenting regarding the impact of regulations, particularly in Illinois, as an example, and additional insights that he has in his role as an Illinois senator. Finally, John Litchfield, partner in the firm's Labor and Employment and Government Solutions practices based out of the Chicago office. John focuses his practice on providing practical, business-oriented solutions in human resources and personnel management. He has been advising clients daily over the past 6 weeks on preparing workforces for coronavirus containment procedures, and more recently, real-time advice on the implications of the new Illinois stay-at-home order. This is a brief view of the topics that we're going to be discussing today. And now we'll begin with supply chain considerations. First step is looking at supply chain operations. And the focus of this portion of the presentation will be on manufacturers and the impact to manufacturing supply chains. However, most companies, even if they're not manufacturers, have a procurement group, related supply chain considerations and strategies that can be applied generally. Given that the coronavirus and government orders are unprecedented, companies need to take a serious and proactive approach to these issues. We've seen companies establish interdisciplinary crisis response teams to identify, assess, manage the risk related to the supply of materials and parts necessary to maintain production, quality, and continuity of supply. Teams should include individuals from all of these areas: purchasing, procurement, sales, operations at the plant level affected, quality, finance, and of course legal. Companies are requiring buy-in from all of these areas across the company to have an effective strategy in place. Often the legal department and legal advisors can provide a risk assessment and assist with interpretation of these specific orders that are coming down and impacting companies. But ultimately, the company as a whole needs to make an informed business decision as to what it will be doing, taking into account the legal assessment and risks. It's also critically important to consider the impact of the orders and regulations. Look at the locations where the company, its critical suppliers, and customers operate. Then consider the implications of each executive order and regulations across the company's global supply chain, looking at the manufacturing footprint, critical suppliers, and important customer contracts. There is a common theme across all of the U.S. locations that we're seeing, and that is, do my operations qualify my company as an essential business? Do the operations support an essential business or essential infrastructure function? This really is not an across-the-board path to continue all operations at the company level. Instead, most companies are looking at this on a location-by-location, manufacturing line by manufacturing line basis, sometimes even down to the specific part or project. It's a highly fact-specific inquiry that companies are doing across their entire supply chain, looking at applicable orders and related risks. There are, of course, business decisions that need to be informed by legal advice and the related risk assessment. And then for companies analyzing their operations, the high-level message has been, if the manufacturer can make an argument in good faith that it is trying to do what it can, what it best can do to help businesses battle the pandemic and keep the employees healthy, or to help support healthcare or other essential businesses or functions, then the manufacturer should indeed do it, while still maintaining the best practices for social distancing, et cetera. But companies that are trying really just too hard to try and fall into one of these exceptions, that are just looking to make money and don't want to shut down, will have an uphill battle down the road and a losing argument that the companies were doing what was right to comply with the spirit of these executive orders and with the language in these executive orders. I was talking to a colleague of mine yesterday, and he summed it up so well that I have to credit this excellent advice to a colleague in our Chicago office, Jeff Sobel. He said, in the simplest terms possible, do not be the mayor in the movie Jaws. The third item that companies are doing in manufacturing is to communicate with their critical suppliers and customers. You need to be aware of the entire supply chain and know how your customers and how your suppliers are treating these orders. How are they interpreting the scope of their operations, and what are they planning to do as far as shutdowns or partial shutdowns? Because that's going to impact your company's ability to maintain its manufacturing lines and supply chain. And then looking to see where there might be a potential battle regarding interpretation and application. We're seeing certain customers claim that they are essential suppliers, but then maybe some of the manufacturers downstream don't believe that they qualify. How will that play out in the coming weeks in the supply chain? When the response team is able to identify mission-critical materials and parts, companies should consider proactively reaching out to those suppliers to determine whether they determined themselves to be a critical supplier that will stay open, levels of inventory they're carrying, and whether there's potential subcomponents or parts that may be in short supply, because companies want to be as best prepared as possible for impacts both up and downstream in the supply chain. And then when possible, some companies are looking at whether they can engage alternate suppliers in other locations that have not been as severely impacted by the pandemic and the ordinances, and looking to see if from an operational, timing, and cost perspective, it would be possible to switch suppliers. Okay, moving on to something that Kate will focus on in much more detail, looking at force majeure rights. One common question that we are receiving from clients is, what about contracts that don't contain force majeure? What do we do if there's no force majeure provision at all? And Kate will talk about some other legal doctrines that we think may apply to these situations. But at a high level, companies will need to assess their rights under the contract, their rights under the law, and not just is this event occurring, preventing performance? Is it making it impossible for us to perform as a result of the government order, the quarantine, et cetera? So these contract provisions are going to vary greatly from contract to contract. You do need to look at each one and see what the rights are. But we do expect to see some common themes once the dust settles on all of this, and anticipate a fairly broad application of force majeure rights and related defenses under the law, given that this really is an unprecedented national emergency and a widespread issue impacting every company. Be aware, though, that many contracts will contain a provision that ties to the force majeure, giving the right to terminate if force majeure is exercised after a certain number of days if performance cannot be resumed. They're also often in more buyer-friendly contracts is the right for the buyer or the customer to terminate for convenience for any reason at all. Okay, looking to monitor customer demands. Why is this important? Well, as this stretches, as the days become weeks, the weeks might become months in this situation, looking to see how your suppliers and customers are impacted in the supply chain. You want to look for signs of troubled suppliers and troubled customers. For customer demands that continue for these essential business operations, companies are going to want to monitor their customers to make sure that they're going to be able to comply with their payment obligations, including timely payment for the parts and services provided. If there are customers that have been identified as a greater risk of non-payment or a greater risk of falling into financial difficulties, companies may want to consider shortening their pay terms and requesting other accommodations to make sure that they're paid for the valuable products they're providing. Okay, so how is this overall working together in manufacturing? Well, what we're seeing is you start with the executive orders, but that's just the step one. The state executive orders do not mandate businesses, even if you fall into something that's arguably an essential business or an infrastructure, to remain open. Instead, they just say that if you tie to this essential business, you are an essential business, you still need to make a determination as to whether you can remain fully or partially open to ensure the supply of critical goods and services. Of course, these orders are encouraging those businesses to do their best to stay open and stay available. Now, if the executive orders do not specifically list the company, which we're seeing, then you need to make an assessment without using a strained interpretation as to whether you qualify as an essential business or infrastructure or support of one of those businesses under the orders. And then notices may need to be sent, including the force majeure notices that Kate is going to discuss. But even if the company is going to remain open, going to continue manufacturing at least certain lines to support essential businesses, there's still additional questions that manufacturing companies are going to need to ask to determine their ability to meet the volumes. First, are these volumes even going to be the same? Probably not. Across many industries, we're expecting volumes to go down significantly. For example, automotive, even if certain automotive manufacturers stay open because some of their customers are telling them, we think we're essential, we're hearing that, while others are still planning to close up and stop their lines, we're expecting volumes to go down. Other important and related considerations for companies to look at. What about your raw materials and available supplies? You need to look to determine if your suppliers have shut down fully or partially in response to the executive orders. You need to be able to maintain your supply chain to continue providing for your customers. And then what about other subcomponents that are going into these assemblies? We need to know what's happening in other supply chains, even though not directly in ours, what's happening with other manufacturers and may have components going into greater assemblies. And finally, what about adequate labor to run the lines in order to meet the customer volumes? There's employee safety considerations, ensuring that there's a flexible and non-punitive sick leave policy in place. Many companies have noted that employee morale will be an issue, and how will companies perceive, how will employees perceive their company's decision that they need to come in and continue manufacturing operations. There's also concerns about employees being exposed and potential claims of negligence down the road that employers are trying to protect against that are going to be continuing operations. And then, of course, maintaining a workforce in this great time of uncertainty with high rates of absenteeism, and some companies are even looking to see, are there certain incentives we can offer to keep employees working? And then for manufacturing lines that do continue and operations that continue, it's important to comply with other best practices and order requirements, such as social distancing, sick employees being forced to self-isolate and stay home, enforced hygiene requirements, and then maximizing capabilities that employees that are not necessary to the daily manufacturing operations can work remotely, having a skeleton crew, et cetera. So these are just some of the steps that companies should take. Oh, one more point. Reviewing actions. This is something that is probably going to be a bigger concern as we near the end of all of this, but for companies that have decided to shut down or partially shut down operations, manufacturers are going to wait anxiously to see when the switch will flip back on. And they're going to want to review allocation requirements and make sure that a reasonable allocation is made across multiple competing customers for what it might be potentially scarce materials during a ramp up. As most companies know, it's not possible just to flip a switch and go from 0 to 100% after a shutdown. There's going to need to be some kind of a ramp-up period, a transition in, and leeway in supply contracts when manufacturers come back online. These are just some of the important considerations that companies should take to address impacts on their supply chain and mitigate risks. And now I'd like to turn it over to Kate Wager to address specific contract provisions and legal defenses that need to be addressed related to the pandemic and government orders and regulations. Thank you.
Thanks, Vanessa. As Vanessa mentioned, we've been getting a lot of questions from clients about force majeure provisions, what happens if a contract doesn't have a force majeure provision, and how they go about contracting right now. So those are the questions that we're going to address in this portion of the presentation. Just briefly, a force majeure provision is a provision that relieves a party from liability under the contract under certain contractually enumerated circumstances. A contract may or may not include pandemic, quarantine, shelter-in-place orders as part of those, but most of the time there's a catch-all at the end that says something like, or any other circumstance beyond a party's reasonable control. And this circumstance would certainly be falling into that category. But the biggest hurdle to claiming force majeure is showing that it prevents performance, not just that it makes it more difficult to perform. And increased costs alone will not be enough. So you need to show that there's no alternative means to fulfill the contract. So if you've determined that you can't your force majeure rights, what is the first thing you should do? First, as Vanessa said, review the contract. Is this current situation covered by your contractual force majeure right? If it is, the next thing you need to make sure to do is meet the contractual force majeure notice requirements. Many of these provisions require that you notify the other party within some time frame after the occurrence of the force majeure event. So to make sure that you don't forego any of your rights under the contract, you need to look at these soon and notify with force majeure letters to your customers. And we've prepared a lot of these for clients if you need our help on that. Next, as I said before, you need to be able to show that there is no alternative means of performing. So you'll have to consider whether there's any alternative supplier that you can bring in, or any kind of manufacturing line that you don't currently use that you can ramp up to see if you can still perform under the contract. As this gets bigger in scope, that may be harder and harder to do, but it still should be considered because it will certainly come up if a dispute ever arises about whether you had the right to invoke the force majeure provision. And then, as Vanessa mentioned, you should also, if this event, if this coronavirus limits but doesn't take away all of your supply, UCC 2615B requires that you allocate your available supply in a fair and reasonable manner. So you'll need to consider that as part of your force majeure plan. Finally, as Vanessa mentioned, you need to make sure you consider the other party's rights if you invoke your force majeure. In a sole source supply agreement, for example, if you invoke force majeure, oftentimes the other party has the right then to purchase from other suppliers. And a common contractual right is the right to terminate the contract if the force majeure circumstance continues for too long of a period of time. So what happens if you don't have a force majeure clause? Are you completely out of luck? The answer is no. There are some common law doctrines, and the UCC has a doctrine of commercial impracticability, and we're going to talk about those in the next slides. So for the doctrine of impossibility, as you might expect, as compared to impracticability, it's a high standard to meet. For example, in New York, it requires that it be objectively impossible. Objectively impossible as compared to subjectively impossible is I cannot do this, and objectively impossible is it cannot be done. So it's a very high standard, but if ever there was a circumstance that might rise to that standard, this could be it. So it's certainly something to explore if your jurisdiction has adopted the doctrine of impossibility. The next one is the doctrine of impracticability. This has been adopted in many jurisdictions as well, and it's actually been codified in the UCC sale of goods context, and we'll talk about it more on the next slide. But as you might expect, it doesn't require that the performance be actually impossible. It might still be possible, but at some excessive and unreasonable cost. Frustration of purpose. Unlike impossibility, under frustration of purpose, performance is still possible, but one party would no longer receive the value of the performance because of an unforeseen event. So it requires that the frustration be unforeseeable, beyond the party's control, and it renders the contract pointless. In some jurisdictions, there's an additional requirement that it be pointless for both parties, which makes the standard even harder to reach. A caveat on all of these is that if these may not be available if there's a contractual force majeure right that doesn't cover the circumstances at hand, courts may look to the contractual provision to prevail. 82615 discusses commercial impracticability. It provides that delay in delivery or non-delivery is not a breach if performance has been made impracticable by one of these two things. The first one is the occurrence of something that neither party assumed would happen when they made the contract, and the second is compliance in good faith with any applicable foreign or domestic government regulation. The caveat with this is that it is only for the sale of goods. This is Article 2 of the Uniform Commercial Code, which is the sale of goods adopted in almost every state except Louisiana. So if you're looking to invoke something like this in a service context, you'll have to look to see what common law doctrines were adopted in your jurisdiction. Potential source of defense is the Convention on the International Sale of Goods, Article 79, which provides that a party won't be liable if he proves that the failure was due to an impediment beyond his control, and then he could not reasonably be expected to have taken it into account. Now this again only applies in a sale of goods context, and only if the two companies are both from signatory countries. signatories to this convention. That would be most commercial players with the notable exception of the UK. But for the convention to apply, it must not be disclaimed by the contract, and in many cases it is disclaimed. So something to consider and look into to whether or not this would apply. Contract in the time of coronavirus. We have a lot of clients who are understandably trying to carry on with business. They are still soliciting and accepting orders, and we have to point out that at this point, all of those UCC and common law doctrines generally require that the circumstance be unforeseeable. And at this point, government shutdowns, supply and labor shortages, mass sickness and death, these are no longer unforeseeable things. So if you want protection under a force majeure provision at this stage for contracts they're entering into now, you'll need to make sure you carefully draft them so that they include events that are either foreseen or unforeseen, and specifically mention COVID-19 and related issues like the quarantines, the shelter-in-place orders, and the like. With that, I turn it over to Carrie Hoffman to discuss labor issues.
Thank you. So, turning employment issues and the Families First Coronavirus Response Act that was passed by Congress last week. The act takes effect on April 2nd of 2020. It applies as defined under the act to employers with less than 500 employees. We've had significant inquiry from clients as to what that means because many companies have multiple extensions, subsidiaries, parents, and the like, and it's a very broad test. It adopts the Family and Medical Leave Act test with respect to how many employees are employed by the employer, common policies, common management, common HR and labor relations functions, common ownership. If it all rolls up into one, it is in all likelihood one employer for those purposes for counting the number of employees. It's very important that you review those kinds of issues with counsel to make sure whether you are or are not covered. The Act itself also provides a potential exemption for employers who have fewer than 50 employees. The problem with that is that it currently says the Department of Labor is to issue regulations, and the department is obviously doing so in between passage and implementation. Therefore, all we have right now is guidance from the Department of Labor that was issued on Friday of last week. That's a joint guidance from the department, the IRS and the Department of Treasury, that they will issue clear criteria and that, quote, the circumstances must involve jeopardy to the viability of the employer's business as a going concern. That may be difficult to satisfy given that there are tax credits for the dollars being paid out under the Act. So it will have to be in all likelihood, and this is speculation more than anything else, that you can't afford to pay the dollars out before you get reimbursed. But we'll have to see what the department says when it issues those regulations. Employers that are subject to the Act, what are they required to do? It's pretty limited, although, again, I understand it does cause some confusion. There were multiple versions of the bill before it became final law and was passed by the Senate and signed by the President. The expanded FMLA allows an employee to take FMLA leave for up to 12 weeks due to the closure of their child's school and or the unavailability of their child care provider, and provided the employee can't telework. If that's the case, weeks 3 through 12 would be paid. The first 2 weeks would be unpaid under the expanded FMLA. There are caps in place of $200 a day or $10,000 in the aggregate. Like the FMLA, before this expansion provision, employees may elect to take available PTO, but unlike the FMLA, employers can't require employees to take available PTO. So again, this is an employee election option to use their available PTO that they may be eligible for under policies, but as employers, we cannot require that. Similarly, for who are subject to the Act, again, between 1 and 499 employees, they must provide 80 hours of paid sick leave for one of the 6 reasons listed. The first 3 are about the employee, him or herself. The second 3 are about the employee caring for a family member that has that type of situation related to the coronavirus. The current one that will start to impact employers once this act goes into effect is the first bullet point. The employee is subject to federal or state or local quarantine or isolation order related to COVID-19. As jurisdictions are issuing stay-in-place orders, it is certainly likely that employees are not going to be able to come to work unless they fit within an essential business, and assuming they can't telework, they will be subject to this. Even the issue of telework isn't 100% clear. If they're subject to an isolation order, technically, until we see regulations, they may be eligible for this leave, although theoretically would hopefully still be working from home. So it's very important to see those issues. But again, if you're able to telework, you shouldn't be eligible for these kinds of leave. Same thing with paid sick leave, like the expanded FMLA. Paid sick leave is paid at the employee's regular rate but has caps. The caps are higher if the employee is unable to report to work for the employee's own isolation order or sickness, and if it's for a family member, it's capped at a lower amount, the $511 per day or $200 per day if it's a family member. Again, payroll tax credits are available, and according to the Department of Treasury, IRS, and DOL guidance that was issued late last week, if you can't afford to fund it, you can seek immediate refunds from the IRS. Again, the IRS is telling us that forms will be made available before the act goes into effect on April 2nd. And so it's important to start looking for those types of guidances as they start to roll out. One thing to consider in the sick leave situation is that it may be very difficult with a very overburdened healthcare system for employees to get doctor's notes. We've been heavily advising clients for employees to take advantage of Teladoc when available if they are unable to report to work due to illness. In general, when it comes to that issue before this act goes into effect, likely we'll be in the same boat as we move forward once this act does go into effect, and so we need to be a little bit more flexible than we normally are about doctor's notes and sick leave. Again, the department, in its joint guidance with Treasury and IRS, indicated that it would issue guidance to us. It did tell us in that guidance, it's a one-pager that says they will not enforce the act for the first 30 days, provided we're acting in good faith to comply with the act. Instead, the department is telling us that it will focus on compliance assistance for employers during the first 30 days as they are trying to fit this issue into the FMLA structure and framework. By way of example, what is the definition of an employer under the Family and Medical Leave Act? Again, as provided we're acting in reasonable good faith effort to comply with the statute, the department is saying it will work on compliance assistance versus violation findings. One issue that has come up frequently and in advance of preparing for the webinar, we got lots of questions from clients on furlough issues. If an employee is furloughed, will they be eligible for leave? Technically, the term furlough really belongs in a unionized collective bargaining setting. It's not generally any different in the day and age in which we live than a layoff unless there's a union contract or otherwise contractual right to be recalled. That being said, we do need to see what the Department of Labor's guidance is and consult applicable state law, but in all likelihood, a furlough is going to be considered a layoff for these purposes, and an employee likely will not be eligible for leave, but we need to be very cautious about how we frame it to the employees as we're going through that issue and deciding how it is we're going to treat employees. For my purposes, the advice we've been giving clients is that the furlough doesn't apply. It's a collective bargaining concept, and we need to go ahead and tell employees our anticipation is that they'll be laid off, and when the business is back up and running post-pandemic, we'll recall them back. And the coronavirus. Reminder that assuming there are no state acts that apply to your business, the WARN Act only applies to layoffs that last 6 months or longer. So if the thought process is we have to close the facility because we are not an essential business or otherwise we've had to close and we believe we'll be back open in 3 months, then we do not have to provide WARN notice. We need to, if we don't know that, or if we have concerns and we want to make sure we've covered our bases, we need to make sure we've provided as much notice as is practicable based on unforeseen business circumstances. the real open question is, how long can an employer believe that this situation is an unforeseen business circumstance? As more and more businesses are requiring to be closed as non-essential, as the pandemic stretches into week 2 or 3, wherever we may be, are we to a place where we really can claim unforeseen business circumstances? Because remember, we have to provide as much notice as is practicable under the WARN Act. Maybe you don't have to give the full 60 days, but we will have to give some notice. And the longer we wait, the less likely it looks to be unforeseen. So do we decide to give the notice, or do we decide to conduct layoffs on a temporary, less than 6-month basis? That's definitely a business decision that has to be made, analyzing the facts and what you think is going to happen with the business, knowing that no matter how you decide, it will be judged, of course, with 20/20 hindsight, and definitely in consultation with counsel, because those decisions are not terribly easy. We've also received at least several questions on what happens to an employee I terminate who's on FMLA leave. Under traditional FMLA, we have no greater right to reinstatement than we would have had if we hadn't been on FMLA. There's some nuances in the amended FMLA that really only apply to small employers. The general advice would be, if you're on unpaid FMLA as it is and you're laying off your workforce because it's non-essential, I would tell them that they may continue on FMLA for the duration, let them continue their medical benefits, however that may be working under FMLA, and then tell them they will not be reinstated unless the business has had the opportunity to reopen. They have the same right as anybody else. If you fall within the expanded FMLA, there's some nuances about exceptions for employers of under 25, but otherwise, generally, the right to reinstatement is going to be there. So that can get a little bit more complicated if we're starting to lay off employees who are technically receiving paid leave. What to do if an employee reports positive test results. It's very important to start to develop protocols to the extent either you don't have stay-in-place orders in your jurisdiction or you are an essential business. We have an obligation under OSHA to provide a safe work environment. So we need protocols when an employee calls and tells us they have a positive test result. The first thing that comes up with most clients is, does the ADA allow me to tell the coworkers in the same workspace that, Carrie Hoffman tested positive? How do I do that? We would normally tell you under no circumstances could you ever use the employee's name. In this day and age, because of the pandemic, we've been advising clients to try and seek and document consent. If an employee will give you consent, and you can document it in some form or fashion, including through a text message, then keep it, and then you can tell the people in Carrie's work environment that that was a real problem, that Carrie tested positive, and here's what we're going to do going forward. If consent is refused, you may not disclose the name under the Americans with Disabilities Act, and all you can do is tell them that a coworker tested positive. You need to notify coworkers of potential exposure. Don't let people come back to work until you've deep cleaned. Provide opportunities for other employees to take leave. Obviously, there are some state law issues about paid versus unpaid leave that you need to make sure you're in compliance with. But anyone who doesn't feel comfortable in the work environment shouldn't be required to come to work. Otherwise, you're going to end up with more concern from employees, and when we come back out of it, we want them to be happy workers. The other question we get frequently from people who are in essential businesses and or trying to keep, the food supply chain going, those kinds of things, is how do I remotely hire workers when all my white-collar employees who do all of that are working from home? The I-9 process requires in-person review of paperwork. Technically, under the rules, employers are not permitted to review I-9 paperwork electronically. So you have two options, is to train a family member who works with or lives with, the new hire to review the documents, as long as the person understands the requirements is the standard. So we could train them via FaceTime or any other electronic means about how to do that and make sure that they've signed off on that. The other option is to have a person at the local location be trained to review documentation and comply with I-9 requirements. And so either one of those options technically comply. The person who reviews the I-9 does not have to be working for the employer. And with that, I'm going to turn on governmental actions to LG Sims and John Litchfield.
Thank you, Carrie. We appreciate you laying out that for us. John, Vanessa, and I are charged with bringing you a couple of different issues. One, we're going to talk about the federal interplay with state orders, focusing on the Illinois executive order issued by Governor Pritzker, Executive Order 2020-10, some of the trends in other states, exemptions and clarifications, but also penalties, enforcements, and liabilities, some questions that we've been hearing from clients and in general over the last several days. We want to start with outlining and identifying federal and state issues and orders. But starting with a quote from our 32nd President of the United States, Franklin Delano Roosevelt, that says the success or failure of any government in the final analysis must be measured by the well-being of its citizens. Nothing could be more important to a state than its public health. The state's paramount concern should be the health of its people. Then talk specifically a little civics lesson about the separation of powers as it relates to health policy. The separation of powers has been granted in the United States Constitution, which provides for a system of checks and balances between the branches of government to ensure no single branch of government can act alone. In matters of health policy specifically, the legislative branch is responsible for creating health policy and allocating the necessary resources to implement those policies. The executive branch is charged with executing and implementing health policies consistent with the scope established by legislative authority. As judicial branch is charged with interpreting laws to resolving any legal disputes. And over the last several years, we have seen courts have exerted substantial control over, particularly over public health policy, by determining the boundaries of governmental power. That power is then granted by the United States Constitution, specifically the 10th Amendment to the United States Constitution, which says that power is not specifically dedicated to the United States by the Constitution, nor prohibited by it to the states or reserved to the states respectively or to the people. So specifically that says that if their powers are not delegated to the federal government, those powers then are handled by state governments or local municipalities or the people. And in this case, we are specifically talking about state and local government responsibility for public health policy. As mentioned, per the United States Constitution, the state and local municipalities retain that primary responsibility for public health. And to fulfill this responsibility, state and local government and state and local public health authorities engage in a variety of activities, including monitoring the burden of injury and disease in the population, identifying individuals and groups that have conditions or public health importance with testing, reporting, and partner notification, providing a broad array of prevention services such as counseling and education, and also helping to assure access to high-quality healthcare services for poor and vulnerable populations. Now, we want to talk a little bit about Illinois Executive Order 2020-10, which is Governor Pritzker's stay-at-home order. But before that, we want to kind of walk through a timeline of where we are and what has happened in the roughly 2 months, less than 2 months, since the first case was identified on January 24th, which was the second case of coronavirus in the United States, was identified as a Chicago woman, to Governor Pritzker's stay-at-home order issued on March 20th, 2020, which is 56 days. So between the first case and the stay-at-home order, we've seen 1,049 cases be identified. We've seen the first case of human-to-human transmission. We've seen Illinois become the first state to conduct in-state testing. We've seen several deaths. We've seen the governor issuing a disaster declaration, President Trump declaring a national emergency over the pandemic. We have seen Pritzker announce additional cases. We've seen the closure of Illinois bars and restaurants for inside dining. We've seen a ban on gatherings of 50 people or more, as the cases of coronavirus hit double digits here in the state of Illinois, seeing the closure of Illinois Secretary of State's offices, including driver's facilities. Then you see the first death, first Illinois death for coronavirus, which was a Chicago resident on March 17th. You've seen Mayor Lightfoot also order all sick residents to stay home and close all Chicago public schools. Then getting to Governor Pritzker's stay-at-home order on March 20th, lasting until April 7th, so 17 days to try to flatten that curve. So we are trying to control the growth of cases to ensure that we are trying to stop the pandemic and address the health issues that we're seeing. So it just kind of gives that timeline as a backdrop for the statement we started out the discussion with from President Roosevelt about the public health and the need to focus on public health as our responsibility, and getting to the intent of Governor Pritzker's order, Executive Order 2020-10. And the intent of the order is to ensure that the maximum number of people self-isolate in their places of residence to the maximum extent feasible, while enabling essential services to continue. When people need to leave their places of residence, whether to perform essential activities or to otherwise facilitate authorized activities necessary for the continuity of social and commercial life, they should at all times and as much as possible and reasonably possible comply with social distancing requirements. So as part of the order, Section 1 of the order specifically outlines the essential governmental functions that are allowed to continue. So services provided by the state or any municipality, township, county, subdivision, or agency of government and needed to ensure the continuing operation of the government or provide for or support the health, safety, and welfare of the public. But also the essential, and this is where we are getting a significant number of questions and inquiries, the essential businesses and operations. So they're focusing and allowing for healthcare and public health operations, human services operations, essential governmental functions and essential infrastructure, and workers which are consistent with the United States Department of Homeland Security's Cybersecurity and Infrastructure Security Agency guidance, which was issued on March 19th. Now, some of those essential businesses that will be allowed to continue to operate are stores that sell groceries and medicine, food, beverage, and cannabis production and agricultural facilities, organizations that provide charitable and social services, media, gas stations and businesses needed for transportation, financial institutions, hardware and supply stores, critical trades, mail, post, shipping, logistics, delivery, and pickup services, educational institutions, laundry services, restaurants for consumption off-premises, and supplies needed to work from home. But also transportation, home-based care and services, residential facilities and shelters, professional services, daycare centers for employees exempted by Executive Order 2020-10, manufacturing, distribution, and supply chain for critical products and industries, critical labor union functions, hotels and motels, and funeral services. And what is defined as a minimum business operation? It's that minimum necessary activities to maintain the value of the business's inventory, preserve the condition of the business's physical plant and equipment, ensure security, process payroll, employee benefits, or for related functions. The minimum necessary activities to facilitate employees of the business being to continue to work remotely from their residences. And we talked quite a bit and had some questions about how the order would be enforced. And the executive order specifically, does not include penalties, but it does outline that the executive order may be enforced by state and local law enforcement pursuant to Sections 17, 7, 18, and 19 of the Illinois Emergency Management Act. Now, there are no specific criminal penalties included in those sections of the Act or the statute, but it also calls for, as we'll see in the next quote from Governor Pritzker, it calls for individuals to self-isolate and self-police. He specifically says that we don't have the resources, capacity, or desire to police every individual behavior. and our first and best option is to rely on Illinoisans to be good members of their communities and good citizens, working together to keep each other safe. It has instructed law enforcement to monitor violations and take action when necessary, but that's not an option anyone prefers. If people who are violating the rule refuse to comply, police may get a cease and desist order from the court. Many local law enforcement agencies have indicated that their enforcement activities related to the stay-at-home order will focus on education, so specifically educating the public of what they are risking if by continuing to ignore the stay-at-home order. We saw yesterday there were 2 instances of large gatherings where police went in and broke up the gatherings, did not conduct any arrests, but specifically made sure that they let the attendees know that they were risking their health and risking the public's health by engaging in or violating those social distancing requirements. And at least one law enforcement agency, the Cook County Sheriff, has indicated that his office will focus, while focusing on education, it will also focus on businesses who violate the stay-at-home order, issuing one-time warnings to businesses that do stay open who are non-essential, followed by potential criminal charges if they ignore police orders. Now, those could be misdemeanor charges, but for the most part, it sounds that, and you'll see indications where if there are specific violations or willful violations of the orders, that there may be some impact on a business's license or licensing renewals. John, if you want to chime in on any of those items or issues?
No, I think the only thing I would mention, and thanks, LG, with respect to essential businesses is that the list is long, and it's meant to be used in a practical way that allows businesses to maintain their basic functions to the extent that they are an essential business. And so, as Vanessa will talk about in a second, that is sort of the trend that we're seeing across other orders as they're issued by other states. But if you believe that you fit within an essential business, we do recommend consulting with legal counsel first, just to confirm that you are indeed falling squarely within one of those essential business categories. But again, that's something that is a trend that's going on, so we'll turn it over to Vanessa to address some of those trends.
Thank you. So now, even as we are presenting today, additional states have rolled out executive orders with regulations and mandates. We're seeing a number of shelter-in-place or stay-at-home orders coming out today, and expect additional ones yet tomorrow. Monday being today, and then tomorrow being the day that you're hearing this webinar. The orders differ by location, but there's a general agreement that the mandate is that people should try to avoid all non-essential outings, and non-essential businesses need to be closed. And then there's specific descriptions as to what qualifies as a non-essential business or an essential business, and we'll talk about that. But there's been a series of states that have closed non-essential businesses outright, indicating that businesses still can operate, but it has to be in a remote environment, so teleworking. And we expect other states to follow suit, and even orders may change over time as the pandemic progresses and the situation worsens in the hospitals. There also are county and city mandates to consider with respect to business closures and orders. So what are the high-level things that we're seeing? Well, we're seeing that essential businesses are defined similar to the Illinois order as John and LG described: grocery stores, healthcare, food production, pharmacies, certain utilities, shipping, banking, government services, law enforcement, emergency personnel, journalists, etc. We're also hearing about critical manufacturing, and there's lots of discussion across different industries as to whether these manufacturing companies are in fact critical whether they at least perform certain manufacturing functions that are critical and will need to continue. And that is certainly a big point of discussion, because a number of businesses, of course, manufacturers and others, perform multiple different services. So it's not that a company does one of these things and that it should continue all operations. It's much more looking at it on a project-by-project, operation-by-operation basis to truly comply with the spirit of these orders and say what is an essential designation and what needs to continue to support infrastructure and essential businesses versus what should we shut down for now in order to preserve safety of the workers. So we're working with a number of different companies and manufacturers on those types of issues, and I know there's going to be a lot of requests for clarification and more clarification sought by different trade and industry groups as this progresses. And I'll turn it back to John and Algie.
Thanks, Vanessa. The next set of slides, and this is bringing it home here, relates to some other client questions that we've been receiving with respect to exemptions and clarifications not be apparent from the orders that we're seeing. And as Algie and I have been advising clients in Illinois, there have been some inquiries about whether an additional exception may be made for a certain company or for a certain industry, or whether the terms of the order are vague enough that there needs to be a clarification from the governor's office in order to try and fit that company within one of the existing exemptions. The answer is that there is no mechanism to seek exemptions or clarifications from these orders. The orders that we've seen do not provide any specific means by which a company or an industry can appeal to the governor for, in any particular state, for an additional exemption or for clarification on what a particular term means in an order. That does not mean that companies can't attempt to seek clarifications or specific exemptions from a governor's office, but before doing so, we really do encourage companies to ask themselves, why am I seeking an exemption to operate? Can I reallocate resources to allow employees to work from home? And is the risk really worth the reward? In other words, is staying open, is seeking an exemption to stay open, worth risking the health and safety of your employees and the broader community and possibly impeding the effectiveness of our healthcare system? If you can answer those questions and the benefits of remaining open outweigh the risks, then it may make sense for you to seek a special exemption or a clarification from the governor's office. But if the answer is no, that the risks do not outweigh the benefits, then we recommend remaining closed until the orders are lifted. Or, as Vanessa said, keeping your business limited to the basic operations that are needed to support the critical infrastructure and other health and safety operations that are ongoing throughout the state. If you do decide to seek a special exemption or some sort of clarification, practically speaking, I don't think you should expect a prompt response from any governor's office. They're overwhelmed, just like many of us are. They're underwater. They are dealing with limited resources, and so we have to remember that the focus of governments right now is limiting personal interactions between citizens of their states, and that supporting the healthcare system is their top priority to avoid overwhelming those systems, as we've seen in Spain and Italy, and more recently in New York. And of course, while self-policing is currently the order of the day with respect to these orders, states do retain the right to use more and harsher methods of enforcement. And so again, you have to ask yourself, if you want to remain open, do you want to risk criminal or civil penalties? Even though, as we'll talk about in a second, there are no current, that we're aware of, civil or criminal penalties contained in these orders, it doesn't mean that they can't be changed at any minute. And sort of more practically, what would you face in terms of a public relations perspective if you remained open and didn't squarely fit within an exception within these orders? And this is particularly true if your peer companies are closing. So the new is what penalties exist, what enforcement mechanisms exist, and the liabilities that may exist as a result of either remaining open or flaunting an order. And these are really driven by some client questions that we have been receiving the last few days. As noted before, most, if not all, of the orders we've seen do not contain specific penalties within the terms of the orders. Some orders, including Illinois, as LG mentioned earlier, refer to state emergency management laws. Those laws may have criminal or civil penalties contained within their terms, so you should check with your local attorneys in your states where these orders have been issued to determine what that means for you if you remain open. Obviously, there are limited state resources at the moment, and so as LG mentioned, they're not currently being allocated to policing the orders in a concerted way. But that could change. This is a very fluid situation, and if there's evidence of large-scale defiance of these orders, there may be more allocation of state resources and city resources to enforcing the terms of these orders. Things can change overnight, as we've seen. They can change in a matter of hours. And it's funny because on Vanessa's slide recently, we developed these slides this morning, which is Monday. And since these slides were developed, both Indiana and Wisconsin have issued their own, or will be issuing their own stay-at-home orders. So the list of states on Vanessa's slide a few minutes ago is growing even as we are trying to put this webinar together. And finally, the issue of liabilities. And I shouldn't just say employer liabilities, I should say business liabilities that may exist if an order is flaunted. Even if there aren't, even because absent the explicit penalties in the orders that exist to date, there are some liabilities that companies will continue to face if they remain open and they don't fit within one of these exceptions. The most obvious of those liabilities are potential tort claims for negligence or willful or reckless disregard of a reasonable public safety order. There's even the possibility, and we discussed this amongst several of us over the weekend, of wrongful death claims. If you stay open and an employee becomes sick on the job and brings that illness home to their family, there is the potential argument that a cunning plaintiff's lawyer could make that because you remained open in defiance of a public order, it caused an employee to become sick and infect their family. And if somebody dies from that, there is the potential of a wrongful death claim associated with that. And of course, as well as basic OSHA and workplace safety violations as well. So to limit your liability, you should limit your operations where possible. And as Vanessa mentioned earlier, that really does take an assessment of your entire operation. Are there segments of your operation that are considered essential businesses? And if so, can those workers work remotely? And secondly, if there are segments of your business that are certainly not essential business functions, do you want to keep them open, or can you afford to shut them down for the time being? If you do decide to stay open, even if it's with a skeletal staff, you should be sure that you follow social distancing protocols set up by your state's order. In Illinois, that is that groups of no more than 10 should be together at any given time, and that folks should remain 6 feet away from each other to the extent possible, even within the workplace. This means that you should maybe even consider limiting access to your lunchrooms or break rooms that may be on your facility, where you can't police employees on an ongoing basis. And so those types of social distancing protocols should be considered in ensuring that you're complying with the status of these orders. And again, we've all been mentioning this, to the extent that you can allow people to work from home, whether that means buying laptops and shipping them to employees so that they can do work in their own workspaces at home, that should be considered. And under some jurisdictions, requiring anyone who can work from home to do so is a requirement. And so all of these things will help mitigate any type of liability if you take them holistically and look at the broader base of your business. And I think that is it for us. We will switch over to the live Q&A and we'll wrap up here.
We hope you found those presentations insightful. And now we will transition to our live Q&A, where our speakers will answer in real time some of the questions we've received. As stated before, if we do not address your question today, we will follow up with you via email.
This is Vanessa Miller. Thank you, everyone, for participating, and we really appreciate the many, many questions we've received via the question app. We're going to walk through some of those. Of course, there were many questions. There's hundreds of participants on this webinar, so we'll do our best to get through some of the broad categories of questions that we're seeing. And with that, I will turn it over to Carrie to address some of the L&E questions she's received.
Sure. A very popular question among many of you was, what are employers doing about health insurance and dipping below 30 hours a week, meaning I may have work for my employees, but they can't work the full 30 hours. What are we doing about health insurance? Technically, under the terms of your health plans, you may have to provide COBRA notice and terminate health insurance. Same issues if the employees are being laid off as part of this process. We have had some success with clients approaching their health care providers and getting waivers of those, and that is something, if you want to continue to provide health insurance, that you should consider doing. How you're going to then get the employees to pay the employee portion of premiums if they're not working and have been laid off is also something you're going to have to work through, but there are ways to make that happen, but it starts with having the conversation with your health care provider. Another popular question we've been getting is about whether the paid FMLA provisions of the Families First Act adds to or limits someone who's already taken 12 weeks of Family and Medical Leave Act. As it stands right now, the paid provisions of the Family Medical Leave Act in the new bill are separate and apart from the 12 weeks of unpaid FMLA leave, and it is something that if we get regulations that we anticipate from the Department of Labor, we may receive some clarity on. But right now, for these purposes, especially given the limited nature of the Paid Family Leave Act provisions, we need to assume that they are separate obligations. And Kate, I'm going to turn it over to you to answer a couple of popular questions.
Thank you, Carrie. We had a few variations of the same question come through about essentially what happens if we're voluntarily shutting our facility down? Can we still claim a force majeure? It's a lot clearer, of course, when a government order is making you shut down, what happens if it is voluntary for the protection of the health of the employees. We are still seeing a lot of suppliers invoke force majeure for, quote, voluntary shutdowns. Sometimes they have raw material or labor shortages, a high rate of absenteeism that's causing trouble for them to manufacture the products. And in those cases, depending on what the language of the force majeure provision says, invoking force majeure can still be appropriate. We had another question come in. I recall that it's difficult to claim excuse by reason of force majeure when the performance that's due is payment. Is that right? Oftentimes, a force majeure provision will expressly exclude payment obligations from an obligation that can be relieved by virtue of a force majeure event. So it's really important to look at what your contract says on that. If your contract doesn't have a force majeure clause, you might see a customer or a buyer claiming a frustration claim in that their market has dried up, so their reason for entering into the contract has been frustrated. With that, I will turn it over to Vanessa, who has some other points to address.
Thanks, Kate. This is Vanessa. So there's a lot of questions as to, we have some functions that are essential. but not all of our operations qualify as essential or tie directly as essential businesses. What does that mean for us? And I think our best analysis of that at this time is that companies need to look, and the spirit of all of these executive orders is to try to minimize your operations in order to protect employee health and safety. So tying only, for manufacturers, for example, keeping only the essential manufacturing operations running, trying to figure out what that is, working with your customers across the supply chain to figure out what that is, to just maintain the essential lines while shutting down the others. And then also implementing, and we've been talking about this a lot in manufacturing because it's going to change certain manufacturing lines and the way they're set up even. Can you employ the proper social distancing and other requirements of having the 6 feet between? What if the lines are set up such that employees are supposed to be right next to one another? How will we be able to change that so that employees safety and health comes first? The other consideration is if a supplier just decides that it cannot make those changes to comply with the orders, it does not want the risk to comply with those orders, what does the mandate say? What do the executive orders say? Well, we don't read the executive orders to say that companies must stay open. What the executive orders talk about is companies that are deemed to be essential, and then non-essential operations should cease. So the company has the decision, first and foremost, to make as to the health and safety of its employees and what it will do. Then you look to your contracts and what you will need to do on the buy and sell side in order to alert the rest of your supply chain. I know that John and LG had some questions they wanted to answer, so I will turn it over to them.
Thanks. We got a couple of questions regarding whether the state executive orders supersede federal guidelines, and really it comes down to the guidelines as established or submitted by the federal government. They're established for guidance, but they don't have the effect of law. As we mentioned in the presentation, the states have the ultimate responsibility for public health guidelines within their jurisdictions. I think it's critical to take the orders that have been issued at the state level and put them side by side with the guidance issued by the federal government to see what's required by the orders and what's permitted by the orders versus what's recommended by the guidelines. Because it gives you the ability to understand what is specific to your respective state or the state where the business is located versus the guidance and the guidelines that have been issued at the federal level. John, if you want to chime in.
And this is John. I'll just add to that that it really is important to look at your specific jurisdiction's order. And while Vanessa, made the point that a lot of these are sort of coalescing around the same type of business exemptions, there's no substitute for reading the order itself or having legal counsel advise you on the terms of the order. So we really do recommend looking at the order terms themselves in order to make a decision. The other another question that we've been seeing pop up frequently, not just on this webinar, but also with our clients, is whether or not employers are required to or should be providing what we're sort of loosely calling the hall pass, but essentially a letter that an employer gives its employees who are deemed to be essential to the business in order to have safe passage and traveling from work to home. The answer is that those letters aren't required under these orders, and even in a place like Illinois, Governor Pritzker said they wouldn't really have the effect of law. If law enforcement stops somebody on the way to work, the question will be mostly, where are you going? And as long as the employee says that they're going from home to work, they shouldn't need to present any type of paperwork to law enforcement. However, there's no real downside to providing those letters to employees, particularly if it improves their morale or makes them feel safer traveling from work to home. So while they're not required under these particular orders, at least as of yet, they certainly are not a bad thing to give to employees if you think it'll help them out in the long run.
Okay, well, barring that, I have a few more. This is Carrie. A few more employment questions I can jump in and answer and then turn it over to anyone else who has some additional questions. One of the questions that's been pretty prevalent today and from clients is about running the paid sick leave requirement in the Families First Act with paid FMLA. Assuming an employee qualifies for both because they need to be home with a child who's ill or a child who's home from school, the first 2 weeks or 10 days of work under the Paid Family Medical Leave Act provisions are unpaid. You should inform the employee, though, that they qualify and those first 10 days will be unpaid. And then if their time runs and fits within the paid sick leave requirements, you'll pay them under that part of the statute. Know that big picture, the leave they're getting for sick leave, if it's not their own illness or their own order to stay in place, will be lower, meaning the dollars that you're required to pay under the statute and that will ultimately you will receive payroll credit for are going to be lower if it's dealing with their child. But yes, you should run them essentially concurrently, as we would call it under old FMLA. Another popular question is, we want to go ahead and start paying our employees for leave now. Can we start compliance before April 2nd, the effective date? You absolutely can start paying your employees whatever sick leave you want, but you're not going to get any kind of payroll credit for it as the Act is, and you're not going to get the clock ticking because the Act doesn't go into effect. And so unless the Department of Labor's regulations give us some indication that there will be more, that there will be some flexibility with that voluntary compliance is okay, which seems like a nice policy consideration. That's not what the law says, and we won't be able to go there. And then, Kate, I'm going to turn it over to you. Do you have additional questions to answer?
Sure. So we had another question come through. Does an event, quote, prevent performance if it could be overcome using only commercially unreasonable means, such as paying 100% more for the same component? Increased costs alone are generally not enough to invoke any of these provisions, but where the cost becomes excessive and unreasonable, a court may hold that to be sufficient, and it's a factual-based analysis to determine where that, quote, excessive and unreasonable line occurs. I think that was all for me. Vanessa, do you have any more you'd like to discuss?
Yes, one question that a number of companies have been asking us, and I'm not an insurance expert by any means, but we have colleagues that are, and we've spoken with them about this, is what about business interruption insurance? How is that going to come into play? And is our insurance companies going to be called upon by the government to step up and pay out claims for suspended businesses? Our understanding of most business interruption insurance policies is that those policies have the condition of physical property damage in order for the policies to apply. Typical examples would be floods, fires, some kind of damage occurs in the building, and that's what causes the business interruption. What in the research we've done and what we've seen from talking with our insurance experts, typically when the government when there's been attempts to try and get insurers to cover that sort of loss, even though there's no physical damage to the property, that has been unsuccessful in the past. Now, it's unprecedented times, but being a contract attorney, I think it's unlikely that the government is going to step in and require insurers to bear the losses of all this unprecedented business interruption and shutdowns, given that these are really contracts between two parties and the risk has been decided by the contracting parties. I'll let LG add anything from the government side on that.
Thanks, Vanessa. Yes, it's LG. We're seeing some attempts by some state legislatures to weigh into this area. There was a bill introduced recently in New Jersey addressing these issues. There's some talk of New York weighing in here in signed by members of Congress reaching out to some of the insurers, trade associations, asking them to consider extending this coverage to companies in this unusual time. But as Vanessa mentioned, these are very specific clauses, and it remains to be seen how these changes will take effect. But we are seeing, and everyone should be on guard for legislative action in these particular areas. Turn it back over to Carrie.
So another popular question from the employment side is I-9s for businesses that are essential and ramping up because they're food service and warehouse and those types of people. Can I do I-9s remotely? Can I Skype in, FaceTime, et cetera? And generally the answer under I-9 regulations is no. You need to physically view those documents. So your options generally are to train somebody who lives in the household with the individual to review documents. I recognize there's some flaws in that system. The other one is to train somebody who's an on-site low-level supervisor in the facility in which they're going to be working and tell them to bring their documents to the facility and have that person review them, meaning you don't have to rely on a family member. You could have that done locally. But big picture, it is not compliant for the I-9 process to be viewing documents electronically. And then, Kate, any other questions?
Yes, we've had quite a bit of questions about retail leasing and if there's any other force majeure provisions that could come into play. The answer we've received from our retail leasing team who's heading up the coronavirus response, namely Matt Impola, is that the same principles would apply. First, the courts would look to whether there's any force majeure provision within the contract itself. Absent that, the same common law doctrine, not the sale of goods ones, but the common law doctrines of impossibility or impracticability or frustration of purpose could be invoked in proper scenarios. They did say from a practical standpoint, many people are asking the landlords for rent abatements, and landlords, when they can, are being accommodating of those. So from a practical standpoint, that may be a place to start as well. And I'll turn it over to Vanessa to add anything she has.
Yes, a number of questions about how the federal guidelines play in, since there's no federal level mandate, as we've seen in some countries, and this is really on a state-by-state basis, sometimes county or city basis. How do the federal guidelines weigh in? And the answer is we have the federal guidelines that talk about critical manufacturing, but it's governed on a state-by-state basis, and the federal guidelines specifically defer to the states to set those regulations for the state pursuant to the health and safety of the specific citizens of that state. So what a number of the guidelines, what the federal guidelines do is they supplement what the state has ordered. The executive order, in some instances, incorporates by reference the federal guidelines. But we're supposed to look to the specific state for the specific rules on that state, and then the federal guidelines are considered to be advisory to the state. I have a question that I think John would be best suited to answer that we're seeing here. There are several questions about, look, I qualify as an essential operation, or I have some essential manufacturing lines that I have to run. Can I, as a manufacturer or as a company, am I liable for negligence if someone gets the coronavirus? Can I be held liable for negligence even though I've been termed essential and told that I need to continue maintaining my operations, or that I should continue?
That's a great question, and it's not the easiest one to answer, but essentially, if you are being careful about who you are deeming essential to your business and ensuring that those folks are maintaining safe social distancing, and you're establishing protocols to ensure that employees and customers that may be in your, or vendors that may be in your space are adhering to social distancing, then that should help insulate you from liability. It should add defenses if there is a negligence claim or some sort of additional claim if an employee can prove, or someone else can prove, that they contracted the virus in the workplace. So I think the answer is you add to your quiver of defenses by taking reasonable measures to ensure that employees are engaging in safe practices while they're at work. But if you're deemed an essential business, then that in and of itself should also add to your list of defenses.
I have at least one more question. This is Carrie about that I've seen from several people on the call about what do we do if we have two parents that work for us, and are they both entitled to paid leave under the statute? Big picture, it doesn't limit it to one parent. Again, the way it's drafted and the way it's incorporated into family medical leave, presumably that's something we would hopefully get from the Department of Labor, incorporating those provisions from FMLA into these provisions such that it would be obvious that people would not be able to take time off concurrently. But we haven't yet received that type of guidance from the department. We do anticipate it coming down fairly quickly. Anyone else have a question that
Carrie,
needs to be answered? Go ahead, John.
There was one more question that was asked about the Family Cares Act, and it related to the official start date. The official date in which employers are required to start complying with that law is April 2nd. Another question that Carrie and I have been receiving from employers relates to whether if an employer provides some sort of similar leave benefits prior to the actual official date on April 2nd, will they be eligible to apply for those tax breaks from the IRS for providing those additional benefits? We don't think that the answer is yes. We think that is no, because the law isn't technically effective until April 2nd. So if you're providing those benefits early, you're doing so out of the goodness of your heart, and you likely will not see a reimbursement or a tax credit from the federal government for doing so. Carrie, I don't know if you had another specific question on that point.
No, I don't have any others other than that. Kate or Vanessa?
Thank you. I just have one more specific question about what if we had already shipped the parts that have been ordered and then we received a force majeure declaration. Shouldn't the buyer, the customer, be responsible for warehousing or dealing with the parts, the cost of sending them back, et cetera? Unfortunately, this is something that's been occurring because of the just-in-time nature of a number of supply chains, and our best guidance that we can say at this point is if the buyer has not accepted the goods and has not received them in delivery, and the title to the goods has not passed to the buyer or the customer, then you are going to be needing to figure out how to get those back to your facility or to destroy them, or whatever the best option may be, the most economic option may be. The important consideration is to track those costs, because there could be a lot of room for negotiation down the road, particularly when supply chains turn back on in full force, and you may be able to recover those costs through some kind of negotiation with your customer. But for now, you can't force a company to take possession of goods when they've declared force majeure if they're not opening their plant. Okay, those were all excellent questions, and unfortunately we do have to draw to a close here. There's been a lot of questions. Will there be a recording of this presentation after it concludes? And the answer is yes. We are going to make a recording of this presentation available on our website. We encourage everyone that's participated on this call, and we appreciate the many questions, to visit our Coronavirus Resource Center on the Foley website. And we are posting real-time alerts, and as events come in, we're updating. So this concludes our webinar and Q&A. Please visit Foley's website in the next few days for a recording of this event, and there'll be a questionnaire. We would very much appreciate your feedback on the program. We look forward to continuing to work with everyone through this time, and hope that we've been helpful. Thank you, everyone.